Hello students, the next important topic is the doctrine of Renvoi. What essentially is Renvoi? Once it is decided that the court has jurisdiction, the next question before it is the characterization of the dispute in terms of private international law rules and deciding upon the nature of the choice of rules that are applicable. If it is English law that is the chosen law, then the judge would have applied the English law on that subject and he would do the same action if it were Indian law that is the chosen law. Thus, where a person dies intestate, domiciled in England, leaving movables there, the rule of distribution contained in the Administration of Estates Act must be applied. There can be no question of paying further regard to the rules of private international law, but the problem arises if the applicable law is that of a foreign country. The situation may be more complex than if it were a local matter decided upon the internal law of the country of lex fori. Here is a simple scenario. Antony, a British subject, died intestate, domiciled in Italy, and an English court is required to decide how his movables in England ought to be distributed. As the cause of action arose in England, the jurisdiction of the English court has been established. The internal law applicable in the situation is the Administration of Estates Act 1925. But as Antony was domiciled in Italy, so the British private international law rules surface here for application. In this case, it states that the law of the domicile should be applicable, and in this case, since Antony was domiciled in Italy, the Italian law should be applicable, but there is a further complexity to the matter. The problem arises about the nature of Italian law that could be applied to this dispute. Italian law as in the internal law or Italian private international law. The complexity arises from the fact that Italian internal law stated that Italian law should be applicable on the principle of nationality alone, and in the given example, the deceased being a British subject by nationality, so the law of Britain should apply. His succession dispute should be brought under British internal law. The process of Renvoi. Renvoi is a French term which in English means sending back. In precise terms, when the choice of law process points a forum court to another jurisdiction's law, the question that arises is how much of that other jurisdiction's laws should apply. Here the dispute along with its legal category is placed under more than one legal system. This transfer from one legal system to the other happens via the route of private international law rules, because the dispute happens to have a foreign element. The whole process of an imaginary transfer of the case into the final decision making forum is known as Renvoi. In other words, Renvoi means an instance of remitting the case to the place of its origin. Renvoi process involved 3 steps in that activity: apply the internal law, a single renvoi, total renvoi. The internal law application The first solution is to read the expression "the law of the country" as meaning only the internal rules of that law. A single renvoi. In the single renvoi, the second solution is to apply the doctrine of Renvoi in the form of single renvoi. Forgo's case is an important example to explain the concept of single renvoi. Forgo, a Bavarian national, died intestate in France, where he had lived since the age of 5. The question before the French court was whether his movables in France should be distributed according to the internal law of France or of Bavaria. Collateral relatives were entitled to succeed by Bavarian law, but under the French law, the property passed to the French government to the exclusion of collaterals. French private international law referred the matter of succession to Bavarian law, but Bavarian private international law referred it to the French law. The Cour de Cassation in France accepted the remission and applied the succession provisions of French law. This is an example of single renvoi, where the reference is merely from country A to country B and back from B to country A. The doctrine of Renvoi appears in its simplest form. It can best be described as remission. Total renvoi. The third possible solution is to adopt what may be called the foreign court theory or the doctrine of double renvoi or total renvoi, also known as the English doctrine of Renvoi. A total renvoi occurs where the reference is from A to B and from B to C. For example, a question arises concerning the testamentary dispositions of Brett, a British subject who dies domiciled in Belgium, leaving assets in England. A Belgian judge dealing with this matter would be referred by the rules of private international law to English law, but he would then find that the case was remitted to him by English law. Evidence must therefore be adduced in the English proceedings to show what the Belgian judge would in fact do. He might accept the remission and apply his own internal law, or he might reject the remission and apply the English private international law. Collier versus Revos is another example. A British subject who, according to English law, was domiciled in Belgium at the time of his death had executed 7 testamentary instruments, a will and 6 codicils. The will and 2 of the codicils had been executed in accordance with the formalities required by the Belgian internal law. The remaining 4 codicils, though formally valid according to the Wills Act 1837, were not made in the form required by Belgian internal law. According to the law of Belgium, the testator never acquired a domicile in that country, since he had not obtained the necessary authorization from the government. The question was whether the instrument could be admitted to probate in England. At the first instance, the case was decided by the English court as the cause of action arises in England, but the internal law of England cannot be applied because he was not domiciled in England. So, English private international law rule was applied and an imaginary transfer of the case came into existence. The Belgian judge's examination of the case resulted in an understanding that the person's domicile was not recognized in Belgium and hence the internal law of Belgium could not be applied despite two codicils being valid according to the Belgian law. Hence, the case was subjected to the application of Belgian private international law and was referred or remitted back to the British law, and the internal law of England was applied. In Re Annesley, an English woman was domiciled at the time of her death in France according to the principles of English law, but according to the French law she was domiciled in England. This was because she never obtained the authorization of the French government, which before 1927 was necessary for the acquisition of domicile. Her testamentary dispositions were held valid by English internal law, but invalid according to the French internal law, since she had failed to leave 2/3 of her property to her children. Judge Russell held that the validity of the dispositions must be determined by French law. His actual decision was in accordance with the view that a reference to the law of the country is a reference to the internal law of that country. Now, the difference between the single renvoi and total renvoi. In a single renvoi, the judge at the forum court imaginarily transfers the matter to the foreign law, which includes the internal law of that country and its PIL rules, and decides the dispute according to the directions of that foreign law. In total renvoi, the judge of the forum court imaginarily transfers the matter to the foreign law, including the private international law rules under that foreign law. The forum court seeks to decide the case exactly in same manner as foreign court. Local court don the mantle of the foreign judge. Local court must apply foreign countries' renvoi rules in order to decide the case in exactly the same manner as foreign court. Now, the options before a forum court. Therefore, there are a few options before the forum court in a dispute with a foreign element. After it has perceived that it has jurisdiction and also classified the factual situation of the dispute to its proper legal category, it could do either of these. A. The court might apply the domestic rule of the foreign country, that is, the law of the foreign country applicable to a purely domestic situation arising therein. B. If the conflict rule of the foreign country refers back to the law of the forum or onto the law of a third country, the court might accept the reference and apply the domestic law of the forum or the domestic law of the third country. C. The court might decide the case exactly as it would be decided by the foreign court. The theories of renvoi. There are a few theoretical explanations for this concept of renvoi. They explain the reason that courts of the forum are called to check the foreign law application, check for the internal law or check for the private international law rules of that foreign law. Mutual disclaimer theory is the first theoretical explanation. Every country shall observe the law of its own as regards the application of foreign laws, provided that no express prohibition exists. The court shall respect the provisions of the foreign law which disclaims the right to bind its nationals abroad as regards their personal stature. Such actions shall be decided based upon the principles of domicile or by the law where the said action occurred. Secondly, the decision of two or more foreign legal systems, provided that they are certain and it is also certain that one of them is competent to have the determination of the question by that system. The theory of Renvoi proper. The doctrine of Renvoi, as has been seen earlier, has two aspects: remission, sometimes called Renvoi in its narrow sense, or Renvoi proper, and transmission, which is called Renvoi in its wider sense. When Renvoi proper or Renvoi in the narrow sense is applied, it would always lead to the application of the law of the forum, especially wherever there is a conflict between the two foreign laws. However, the assumption behind Renvoi proper is that the rules of private international law in each country are based on the principle of comity, implying a mutual agreement among the states for the application of each other's laws. In other words, it is founded upon reciprocity. The foreign court theory. Sir Herbert Jenner, sitting as a judge in Collier versus Revaz, made an excellent summation of the theory behind Renvoi by naming it as the foreign court theory. He opined, "The court sitting here decides from the person skilled in that law and decides as it would if sitting in Belgium. In a case of testamentary disposition of the property of a British subject domiciled in Belgium, the English law will direct the court to examining the Belgian law. Looking at the Belgian law, the English judge could come to the understanding that English law needs to be applied because the Belgian law, also allowing on principles of Renvoi, said that testamentary disposition should be founded upon the law of nationality. In this case, it is England. So, the judge applies the English law because the Belgian law directed him to do so. In order to analyze the judicial and thus legal position of the doctrine of Renvoi in international context, it is important to first see the application of the doctrine. The doctrine has been applied to, firstly, formal and intrinsic validity of wills, secondly, cases of intestate succession, thirdly, legitimization by subsequent marriage. However, there are indications by the court and the jurists that it also might apply to formal validity of marriage and the capacity to marry. The difficulties of applying the principle of Renvoi. the main difficulties in the application of the doctrine as highlighted by the judicial responses and various conventions curtailing its scope are as follows. The Convention on the Law Applicable to Contractual Obligations in a way has curtailed the scope of the Doctrine of Renvoi for the European continent, at least as this convention is a European Community Convention. Article 15 of the convention clearly excludes the operation of the Renvoi by stating that the application of the law of any country specified by this convention means the application of the rules of law in force in that country other than its rules of private international law. Some of the criticism that was levelled against this principle of Renvoi centered on the following points. 1. Where there is a doctrine of Renvoi approved and applicable in the foreign system also, then there could be a constant remission of the matter, leading to something called as circulus inextricabulus. This principle would be completely successful only if the other legal system does not recognize Renvoi, thus leading towards a decision in the dispute before the court instead of a constant remission. 2. It could be very difficult for a judge to perform the task of placing himself in the shoes of the foreign court's judge, especially in circumstances where there is no authoritative judicial statement from the foreign court in any matter that the court is seized of, and there were a couple of contradicting decisions from the lower courts in that foreign legal system. 3. Renvoi is not an important fillip in promoting the cause of uniformity of laws, which is the primary vision of private international law. 4. Another major difficulty with the doctrine is that with so much of remission to foreign legal system being adopted by the court, where there are multiple legal systems involved, it could create a maze of systems, often contradicting each other in the interpretation of the principles in the issue that the court is seized of. 5. Applying the principle of Renvoi could also lead to a duality of opinion on the same issue. For example, an Indian court is seized of the matter of distribution of goods belonging to A domiciled in Russia. Since lex domicile would govern the matter, the court should give a decision as would have been given by the court of domicile. The Russian law in this example has a different statement. If the goods were in Russia, irrespective of the nationality or the domicile, the Russian law would apply, and if the goods were outside Russia, then the Russian law would be inapplicable irrespective of the presence of nationality or domicile. There comes the issue of difference. While the theory of Renvoi suggests that domicile law needs to be applied, the foreign legal system has a completely different idea and decides the matter on the position of the goods rather than on the nationality or domicile of the individual. Instances of application of the principle of Renvoi. A few cases where Renvoi as a concept has a major influence on decision making are: 1. In instances of dispute over immovable property situated in foreign land, there has been uniform opinion across the legal systems. the lex situs of the immovable property will be the applicable law. The reason for applying the lex situs is that any adjudication which ignores the lex situs would be brutum fulmen, since in the last resort land can only be dealt with in the manner provided by the lex situs. 2. It has been suggested that the doctrine of Renvoi should be applied to foreign movables situated abroad, but such suggestion did not gain much acceptance. As to the status of marriage, it has been suggested that a marriage that is recognized in the lex domicile should also be recognized everywhere. This principle being also applicable to changes in the status of marriage. 4. The doctrine has had much application as regards the disputes on the formalities of a will. Much of the literature on the subject is of the opinion that the doctrine of Renvoi has limited practical utility. It is necessary to recall here the provisions of the draft Hague Convention, which later came to be the International Convention of Private International Law 1951. These few provisions state: 1. When the state where the person is domiciled prescribes the law of nationality, but the state where the person is a citizen prescribed the law of domicile, then each contracting party shall decide the matter on the application of the internal law of his domicile. 2. Where both the situations prescribe the law of the domicile as the applicable law, then each contracting state shall apply the internal law of his domicile. 3. Where the law of the state of domicile and the law of the state where the person is the citizen prescribe the law of the nationality as the applicable law, then each contracting state shall apply the provisions of the internal law of the nationality. To conclude, we have now learnt the process adopted by the court to decide upon the law applicable to the substance of the dispute where the facts present a foreign element to themselves. Upon an affirmative decision on the jurisdiction, the forum court, instead of applying the law of the forum, would resort to its private international law rules to determine which law is applicable to the dispute. Through the forum's private international law, it makes an imaginary transfer of the case to another jurisdiction that is connected to the dispute. Then it tries to imaginarily position the dispute within the legal system of that country and check whether the internal law or the private international law rules of that country apply to the dispute. Such imaginary transfer could be done either once as in single renvoi, or twice or multiple times as in total renvoi. In a total renvoi, the dispute is likely to be remitted back to the forum court for decision. This activity of imaginary transfer of the dispute between more than one legal systems, while ensuring justice and fairness to the disputant parties, is also a difficult task, especially in systems where the private international law rules are not well evolved.